So we will call the meeting to order at 7:01. Let me go ahead and set up. Things they've moved things around today in Zoom a little bit. There we go. So meeting called to order at 7:01. I've turned on captioning. That's one of the requests that the town actually makes for meetings. And with that, I've turned on my video as well, so you can now see that I'm actually a live person, not just a talking avatar, as the case may be. So anyone from the public, perhaps the name Brian, that wants to speak at this point in public engagement, otherwise we can certainly have that discussion as we go forward. If Attorney Bobrowski doesn't join us shortly, I'll reach out to him again.
He sent an email to the group indicating that he can't find the Zoom link. Can you please resend?
I will go ahead and send him that link. Not everyone has technical affinity at the same level. And it looks like he's joining us. Excellent. Well, welcome, Attorney Bobrowski.
Hello. I figured if I went to the agenda, I'd get the Zoom information. So here we are.
So excellent. Glad to have you. So first thing on the agenda, we've gone through items 1 and 2. We have the minutes themselves. These are the minutes from April 1st. These were in the Dropbox link for everyone. Do we have a motion to approve the minutes as presented?
So moved.
Anne has made the motion. Do we have a second?
Second.
Tim seconds it. In addition to taking the minutes, doing double duty for us, Tim. Much appreciated. Okay.
Lucy's taking the minutes.
Oh, Lucy's taking the minutes.
Change it up. Yes.
Okay. So Lucy, you're the dedicated recorder. Appreciate that. If you can just post the file into the Dropbox folder when you're done, that'll be appreciated. So any comments on the minutes from the last meeting from April 1st? They have the members, how the meeting was held, when it was held. Minutes were all votes were taken by roll call, and the votes that were taken, namely the vote to adjourn. There were also some other votes to approve the proposed bylaws for non-conflict with the recodification for the zoning bylaws at town meeting. Any comments on the April 1st minutes as presented? Seeing none, we've got a motion made and seconded to approve the minutes. We'll go with the roll call in the order in which you appear on my screen. Anne?
Yes.
Tim?
Yes.
Lucy?
Yes.
Joe?
Yes.
Kevin?
Yes.
And I'm a yes as well. So with that, minutes are universally approved. I will go ahead and put the standard footer that I put on to the minutes when they're approved. It says the date that they're approved by. So if you ever want to know what that actually looks like, you can usually see that on the website after they get posted. I then send a copy to the town clerk and to the administrator. In our case, it's Sherry Dalton, who puts it onto the website. The town clerk retains a copy for records and in case someone asks for it, so that she has ready access for that. So the minutes are taken care of. Item 4 on the agenda is to review bylaws and expectations for the April 29th town meeting. 2 weeks from yesterday, we have a town meeting. There are a lot of items on the warrant. The warrant is out. If you haven't taken a look at it, I do recommend it. recommend reading through it. It is, I think it's 4 newspaper pages long, and that does not include the maps. So it's a long warrant. It has 4 different zoning articles in it. It has 4 other bylaws. It has some political items, and it has little things like a budget and some other changes that are being recommended by the town. So a bunch of different items on the warrant. Please familiarize yourselves with the elements of the warrant itself and the items. I know that everyone here has been through at least the zoning articles in depth, and we've had at least some discussion of the other bylaws. Please take a look at the other items that the warrant covers, because I think you'll find it to be very useful as we go into the meeting itself. My expectation, as we get started, is that this meeting, because of the length of the warrant and the complexity of the items, is likely to last 2 evenings. So I recommend that you specify and reserve April 29th. In addition, I recommend Thursday, May 2nd. Typically, these meetings go Monday and Thursday when they're held at the Galvin. That's been the historical way. It's not guaranteed to happen that way. It's at the end of the meeting when there's a motion made for the meeting to be continued to a specific date, time, and location. That's when it gets specified. But historical precedence, it was that it used to be Mondays and Thursdays is when town meeting would occur. Please try to arrive on time just so you can hear the various elements of the meeting itself. If you wish to speak on any of the articles, please keep in mind that by bylaw, we have a 5-minute limit. If you wish to speak longer than that on any article, where I know everyone here has knowledge, especially of the zoning articles, if you wish to speak longer, my suggestion is to let the moderator know in advance that that's a possibility and request it of the meeting. It requires a vote of the meeting to have an extension of time. Otherwise, the current plan is, as chair, I will recite a very short statement for each of the 4 zoning articles, that it is not incompatible with the work that this committee is doing on behalf of town meeting for the future. And that will be the extent of this committee's official input into any of the articles itself. We've decided not to take any formal stand on any of the articles, including the MBTA communities article. It will be up to the meeting as to what happens with that. But the advice and guidance that we've gotten from our esteemed council is much appreciated. And if people ask for anything along those lines, I will refer to council. We also, of course, will have town council present at that particular at those meetings. So Tom Mullen will be there, and he can give his opinion on any items. He would be responsible for defending any bylaws that go into effect. So you are welcome to speak. If you do speak, you are welcome to state that you are a member of this board. You are not required to do so by bylaw. Custom is that if you are on a board that's relevant to the topic, that people do state that they are on such and such a board, either appointed or elected. But again, there's not a requirement to do so. I do encourage you, speak your mind as in your opinions on any articles that you so choose. So that's just where things are. If you're not familiar with the rules of the town meeting, you're welcome to pick up. There are a couple of books. This is the actual Bible for town meeting. Yes, I actually have it on the bookshelf behind me. It's called Town Meeting Time, and it's what the town moderator actually loves to use as his primary legal reference. It's kind of like they tend to go to Attorney Bobrowski if they have any questions on zoning. So that's the book that's used for town meeting management. So again, please feel free to participate. I highly encourage it, because this is how we actually implement the bylaws. And people may have questions. I anticipate they may have questions on what is the implications of various bylaws, and will these things be reviewed? And the answer is we're reviewing all of the bylaws. Once a bylaw is approved, if one is, then it becomes fully ripe for us to review again. So any comments, questions, thoughts? Otherwise, I'm definitely looking forward to seeing all of you at town meeting. And that's actually all for the members who are here. For some of the other members, there's some other issues that can come up from time to time. I address those with those members as needed. So with that, it brings us up to item 5. Attorney Bobrowski, the zoning bylaw recodification draft. And with that, you'd asked us to fill out a sushi menu. I must say that I found the spicy fishes to be most delicious, followed by a tuna roll. And at one of our sushi restaurants, we even have sushi burritos. So we have a wide variety of different things. One of our sushi restaurants, we have 2 of them in town that specialize in sushi and several others that serve it. One of them even is wonderful for having gluten-free menu items as well. So in gluten-free miso soup. The other one does not have gluten-free miso soup. Learned a variety of things. So we've have had a sushi menu of items with that. I can go ahead and share the section 3 if you'd like to start there, or if you'd like to start somewhere else.
I'm gonna put the sushi menu up if I can share screen. You got me going here because
There you go.
I had Indian food tonight at a new restaurant in Sudbury. And it came in a lot hotter than I thought it would.
And speaking of Indian food, we happen to have a fantastic Indian restaurant here in Wakefield. So if you like it, if you like to have East Indian food, they have both northern cuisine and southern cuisine. Highly recommend it. It's on Tuttle Street. It's a restaurant called Maya. Feel free come into this area, and it's one of those things that they've great food as well. So we've got sushi on the menu. We've got Thai on the menu. We've got lots of Italian. There's probably several dozen great Italian restaurants, and of course we do a really good Indian as well.
Well, I found this restaurant. I was at the TWA terminal. I don't know if any of you have ever been there at JFK. It's famous. It's iconic architecturally, and it was mothballed for, I don't know, 30, 40 years. And if you've seen the movie with Leonardo DiCaprio, where he plays a pilot, he's not really a pilot. Catch Me If You Can. A lot of that is shot in the red and white TWA terminal. So we're sitting at the Jean-Georges restaurant, and the waiter is an Indian gentleman. And I'm complaining about the lack of good Indian food in this area. And it turns out he's from this area and he knows them all. So he referred me to one in Sudbury. And I, for the first time, went over there tonight and told them about their nephew or whatever he is, drumming up business for them at JFK. So you never know. All right. So I'm going to walk through this, and I guess we'll just take it a piece at a time.
So Mark, can I stop you for real quick?
Sure.
This is Joe. So I brought this up last week at the ZBA. We had a little discussion, a little powwow on this section, the whole section, not all 10 pages, but so some of them were actually going to come to this meeting, but I think some of them had some conflicts. The chair, Tom, they stressed some concerns about this whole section, adding it to the bylaw. I didn't really want to speak for them. I thought they may try to, like I said, make the meeting, but I think they had some conflicts. So I took a few notes from a little discussion. I think some of the feeling is that it kind of binds our hands a little bit, I guess, because Wakefield's not a cookie cutter town. It kind of gives like no flexibility, I guess. Some of the projects that that we may like that come in front of us may not be able to follow a lot of these standards, and there might be a couple other projects that we may not like, and they check every little box on this. So I think that was some of the pushback by um, Tom, who was the chair, and a couple other members. Um, they also mentioned, let's see here, like, I guess it's like we'd like to have like the this have the like a discretion, like if it could be like in front of the discretion of the board, but that it's kind of hard to, I guess, have a bylaw and then have us have a discretion, like, oh, can we change some of these? Yeah, I don't know if it's something that you've seen in other towns. Um, you know what I'm saying? Like if we put all these rules and regulations in, it it may, like I said, it may bind us, you know, tie our hands
Well,
behind our back, I guess what I'm trying to get at.
I appreciate that. Thank you. Um, let me say a couple of things about that. I'm looking at the site plan review criteria that you have today, and these are in the draft, the first draft. So when the board makes a decision, if you look at section 10.7.7, this is what your bylaw says today. I didn't change it. Well, no, I may have changed a little bit of this, but essentially you're looking at protection of adjacent areas against offensive uses, surface water drainage, lighting, sight, sound, dust, vibration, and convenience and safety of vehicular and pedestrian movement. How do you handle refuse and other production byproducts? Environmental protection. What's the lay of the land with regard to the arrangement of structures? And then the systems for access, drainage, water supply, sewage disposal, lighting. That's, you're making a decision today on these standards. Nothing wrong with that, except they're entirely subjective. It's sort of like I've seen some site plan review bylaws that say minimize this or maximize that. Again, very subjective. So the thinking in section 6.3 is that you're going to make standards for things just like you already have done for signs and parking. Signs and parking are not subjective, they're objective. You've got a table under parking that says, this is how many spaces you need. This is how wide the aisle is. This is how many curb cuts you can have. It's not minimize or maximize. It's a definitive answer. And the things that I've got here in section 6.3, lighting, noise, site preparation, motor vehicle, and pedestrian safety, are really what you've got buried in this decision criteria section. So the question is, when you go to site plan approval, do you have enough information really to make an objective decision? There is a provision at the back of the section that we're talking about tonight, section 6.3, that allows you to, be very flexible in that you can waive any standard. Just scooting to that, hang on. So at the very end of the section, it's in the procedural stuff, which I did not include here. But there is a section at the back end that says waiver of standards, and it allows the special permit granting authority or the site plan review authority to make a waiver whenever they deem it to be appropriate. So you're not stuck with the standard. It doesn't lock you down. You can work around it by simply voting a waiver of the standard. And it's not a waiver of the procedures, it's a waiver of the standard itself. But it's your call. I mean, this is, I think in a town your size, to just have parking and signage standards leaves you a little short. Lighting is a big issue in many communities that are getting more crowded. Noise certainly
Well, to go back to lighting, that was like a couple of the thoughts on the board were like where it says height of fixtures you have there. I mean, I guess this is one of the things we could take out is 15 feet above ground, and then you have the pole, no more than 20 feet.
Yeah.
I mean, does that mean once that's in there, doesn't that hold them to it, or does that say, well, we don't meet the 20 feet standard, or that we're not going to meet the 15 feet above grade. So now we're taking that out, like,
Well,
is that
let me,
something that
let, yeah, let me go back to the first draft again. Because in the first draft where you've got the section 6.3 without really having discussed it yet. Let me just scoot up there. So this is the very end of the entire section 6.3, including the procedural sections that I pulled out when I sent you the sushi menu. So there's the last, these are the last of the standards, fiscal analysis, and then here you go. 6.3.11 waiver of standards in the course of granting a special permit or site plan approval may waive any of the performance standards where such waiver is not inconsistent with public health and safety. That's not a tough standard to beat. And where such waiver doesn't derogate from the purposes of this section. So I don't know if that's, that
well,
it's there. I don't know if it's good enough, but it's there.
yeah. I guess what I'm getting at, and if Dan, if you want to chime in, I sent you an email last week. I don't know if we want to set up like this instead of trying to get this done tonight or even look at it. If we want to set a subcommittee with some of our ZBA members and maybe the planning board with Theo and try to dive into this, because I don't know what his thoughts were on this. I know he's got to deal with this a little bit also.
Yes. I'm
So
here to do what you want to do. So if that's the way you'd like to handle it, I'm fine with it.
yeah,
Joe,
I think that
did your board not think that the waiver gave you enough flexibility to move off of some of the requirements?
well, I mean, like I said, we spent about a half an hour on it. We didn't go through it. Like I said, when they looked at it, they just thought it was a lot of standards for some of the projects. Like I said, they were under the impression that like I said, there might be some projects that may not be able to, I know that I guess at the end of the day, the waiver does cover all that. So I don't know. I mean, I just don't, like I said, I don't want to speak for them. I thought all 9 or 10 pages was a good place to go. And I mentioned to them it was like a sushi menu that we could pick and choose. And we didn't get very far. Like I said, I invited them to this meeting so they could explain how they thought. And like I said, there was a conflict of interest tonight. So like I said, I don't want to speak for them. And I think it might be better to table it and try to get more of like I said, my fellow members here and maybe even the planning board and see what their thoughts are.
So in the interest of both time and appropriateness, I think we should go through the standards and the feedback that was given to Attorney Bobrowski. And this will be revisited several times. And I think the comments that you're stating are appropriate, but because they are reflective of what other boards are stating. I suspect from the way you're describing it is that they're stating it without the full context of what these standards are. These are a starting point. Because they can be waived, this is the general expectation. And that expectation, subject to the special permit granting authority, whether that happens to be the ZBA or the planning board, depending upon the individual project, where it is and so forth, this gives a starting point for what the expectations are by the town meeting. And if there's going to be an exception, the exception can be there. It just has to then be explained by that board. And that is typically done during a meeting. That's normal course of business. And I don't see that as being difficult. I also don't think that we need to hold this for additional feedback before we go through an initial pass of it. We represent the town to make not final decisions, that's town meeting, but we represent the town to at least make an initial pass of this. And then I think additional input is certainly welcome. And this is one of those sections that is likely to get revisited multiple times. I see this getting revisited multiple times. I see the definitions and the districts. The three topics that I listed for tonight as being items that are likely to come up in different components as we have different drafts, because we're still only reviewing draft one. So that's my sense in where we should go, so that at a minimum, the members of this committee will have a better understanding of what these standards are really about and why we may want some or all of them based upon the feedback that was given to Attorney Bobrowski and recommendations of the committee as a whole. So that's my 2 cents. If others on the committee want to chime in, it's certainly a pertinent topic.
Yeah, I mean, I agree with that. I mean, if you want to go through it, it's fine. I can, like I said, I can take some notes and we have a meeting next week and I can discuss with them and see where they want to go with it.
All right, let's see how fast we can go through these things.
And Attorney
So-
Bobrowski, did you get feedback from committee members?
I got nothing in terms of somebody ordering sushi.
I know I sent back
I did
mine
get
today.
yours, Mr. Chairman. Yeah. But you know, it's everybody's busy and it was a holiday. It didn't surprise me because I'm still recovering from the ride home from the eclipse. So it was a wonderful Globe article about 2 days after it happened, in which the author warned you that she would use trigger words like Franconia notch, and it was amazing. So lighting is the first topic, and what we're trying to do here is just set some basic standards. Now, these are not guidelines. Guidelines have no regulatory force. It's like policy. Policy is not regulation. There's actually a wonderful case from North Andover called Field Crest Meadows, in which there's a policy at the Conservation Commission that you don't touch within 25 feet of the resource area, but it's not a regulation. And the appeals court says, then it's not a regulation and you don't have any right to impose policy. So these are standards. That's the reason they're called standards. And they're pretty basic. So we can take them one at a time. If I'll go through them quickly. The first one is just, basic cutoff luminaire, which is the technology. Light trespass is to be confined within the property boundaries. So we're looking at overspill and glare. This shouldn't leak onto your neighbor's property. It's not that the neighbor shouldn't be able to see your light. It should be casting light. And to the extent that the dark sky standards are feasible, they should be applied. This one on outdoor lighting and light intensity has a lot to do with shopping centers in the evening. Most shopping centers don't manage their lights by timer and they stay lit up. So you can require that some of the lights be turned off. Light what your intent is. So if you're putting surface lighting, it ought to basically light the ground and not the nearby trees. Searchlights are prohibited. Indoor lighting is not to be projected outside in a manner to defeat the intent of the section. Outdoor signs are restricted. We don't want any flickering or flashing lights. Height of fixtures we've already mentioned. Hours of operation can be set. Motion activated lights are encouraged for security purposes. That's pretty much, common sense wisdom on standards for lights. A lot like it's common sense wisdom that you have sign bylaws that allow some signs in some areas and prohibit signs in other areas. I guess I'll stop. There's like 9 of these sections, so I guess I'll stop and revisit any that people want to talk about or ask questions about. I should say that the origins of this performance standards section come from Westford, where I was asked to serve as marriage counselor between the new people in town and the planning board. Planning board was getting a bad rap because the new people who had moved into town thought they weren't being tough enough on native businesses. And so I worked with the planning board to adopt standards that they've changed over the course of the years, but that's basically why this section got invented years ago. And the thinking again is, if you're going to objectify parking and signs, why not objectify lighting?
So just to add on to that, this was in a comment that I sent to Attorney Bobrowski. If we can go to number 2 on that, which is the light trespass. This is, and I think this also gets to the discussion we were just having about the waiver of standards. So one of the things that I looked at here is I can absolutely envision projects where light trespass is natural for a project, especially if it's a commercial type of property that is, especially if it's on a boundary type of district, it's something where depending upon the type of project, it could absolutely overspill to another property. If we've got a concrete company in town, we've got car dealerships in town, those types of properties often will have light spillage, and they need light for safety. So I don't have a problem with that light. My thinking on it, though, and I'm not sure how to word it, is that any sort of exceptions for that should be limited in scope only while the purpose for which it's being limited exists. So that way the permission to have that lighting that goes outside of the property boundaries, say for a car dealership, is permitted while it is a car dealership, and that gets built into the special permit. When that use is no longer needed, then that standard reverts back to the regular standard. I'm not sure if that can be written into the bylaw so that it then applies to the special permits that get granted once the bylaw is adopted. But that was where I looked at this, and that was one of the areas where I said, I like the concept, and I can see where instead of just doing a waivers that are connected to use, then when the use is no longer done, the waivers effectively disappear so that we go back to the standard itself. And this, I think, gets to the goals of having standards and allowing for the flexibility that the ZBA is actually created to provide.
So I'm jumping back to your site plan review section, because I think that change of use is a trigger for a new round of site plan approval. Yeah, 10.7.2, any new development, expansion, or change of use basically result in another site plan exercise. And obviously, if it's going from a car dealership to something that doesn't need lights 24/7 for safety or security, they're going to get their own new approval, and it will basically redesign the lighting for the premises, or at least it should. I'm not sure if you're familiar with or have experience with photometric plans, which are easily obtained these days because people want to sell you. They want to sell you lights. So the typical lighting installation company can now do a photometric plan And you can actually see if there will be spillage or intrusion from light, from glare coming off the property onto the adjacent property. But I think your point is well taken, that you could actually do some guidance here by saying, can you see it again, light trespass?
This was on light trespass.
Yeah, so that's what I have on my screen. So at the end of the first sentence is to be confined within the property boundaries, except where necessary, for safety or security. There's something that can be added there to at least provide a standard for that.
And the real purpose behind it is defining what is the change of use, because a lot of the uses that are initially granted are quite wide, as opposed to the actual business operations for which the standard is being waived. And that's where I'm trying to reconcile those differentiations, such as a property is being constructed initially as a car dealership, but all of a sudden now it's not being used as a car dealership, it's just being used for, say, car storage, which is a similar type of use, and they're not likely to go to the ZBA because they'll say that it's still substantially similar use, but it's no longer the use for which the standard was waived. So that's where I'm just wondering if there's a way to build that into the bylaw so that that level of detail can trigger either a full site plan review or at least a site plan review of the standards that are being waived, because it may not necessitate a full site plan review, because I don't want to create yet more work and unnecessary work for either a property owner or for a board of volunteers that are really trying to help benefit our town. I just want to, but by the same token, protect the standard of living in the town itself. So I'm trying to figure out how we can cut those pieces together.
Well, you could either put that standard in the bylaw, although I think it would be difficult to imagine and specify the degree of change as a trigger, or you could put it in the permit decision, so that if a car dealership gets site plan approval and or a special permit, you could put a condition in that to the extent, volumes of sales decrease by more than 50%, they have to come back in because it's a change of use, and you can reset the standard.
Others' thoughts?
I guess my question is it necessary if there is a change, wouldn't it have to be revisited?
Yeah.
So do we need something, Dan? Are you just trying to give transparency that is if there is a change, they would need to, it would end any waiver they receive?
I'm trying to give the transparency and the expectation that if there's a change, it ends unless a new permit is granted.
Right.
So that way it becomes really clear to someone who's not a zoning expert, not a land expert, and I don't profess to be either, that, okay, we expect that this is a standard that is likely to be waived, but upon that use changing, it may require a overall view, but this, for a few of these that really impact the quality of life for the neighbors in particular, I think that putting something that reminds both the person reading the bylaws and as well as the special permit granting authority that this is something that they should be particularly aware of in granting exceptions. It kind of highlights that, hey, this is something that you want to really limit what the use is if you're going to grant an exception. Doesn't say that you shouldn't or can't. It's just putting that highlight in for it so that if there is a change, it would actually have the ability to even give neighbors and so forth a a level of standing to go to the town to say, hey, this is a change of use. Can you contact the landlord, see what's actually happening here? Because it seems like special permit use may be needed without a person having to know much about land use or law, or necessarily even be particularly involved in town government.
I think change of use is definitely a trigger for a new round of permitting. You're describing the rare situation, Dan, in which a car dealership turns into car storage because the dealership has less activity and, they're very closely related uses anyway. I think the place to put that trigger, it would be in the actual approval, the site plan approval the first time around, with some sort of a condition that if the sales volume decreases more than 50%, that shall constitute a change of use under the site plan review decision, and that they have to come back. But to predict it in the bylaw section rather than in the permit section, I don't know how much. I don't know how you could write a bylaw that would predict something like that.
Okay, that's fair enough, and I just raise it because it's an issue that I have seen come up where there have been substantive changes of use, and where I haven't seen those substantive changes of use necessarily result in people going forward to knowing that they had to go forward to the ZBA.
Yeah, but this is a very interesting world in which you have a building commissioner who drives around town, and you've got plenty of neighbors keeping an eye on everything. So to the extent a car dealership turns into, I don't know, pick your poison, I don't think it's going to go undiscovered. I mean, every time, I have this conversation in other towns. Everybody knows what's going on. Everybody's into everybody else's business for the most part.
Depends on who. We certainly have our fair share of loud neighbors.
Well, there's nothing wrong with people deciding that they need to protect their interests by telling the building commissioner that something changed, and what was good 20 years ago is no longer applicable because it's changed that much. I mean, there's a building commissioner that I used to work with, Joe Peruzzi from Ipswich, and he would haul you in to the enforcement realm if your trees died and you didn't replant them fast enough. He actually shut down places, pulled their CO. They had to plant pine trees around the chain link fence. 10 died. He told them to replant. When the season came and they didn't replant, he pulled their CO. That got their attention.
Other comments, questions on this section? So one of the other comments that I will add is the illuminated surfaces. And I wasn't sure if that was a section that really needed to be specified as a performance standard, and whether that was needed or not. Because part of it is I don't want to have standards in here just for the sake of having them. Yep. I wasn't sure of how much of an issue that was. And for those of you who are on the planning board, ZBA and so forth, is this a significant issue? Is it something that we should have as an explicit standard?
I like the last sentence though, Dan. I mean, I represent McGovern Subaru, and we just bought a shopping center in Acton. And this was something that the Acton Board of Selectmen, who does site plan approval, used, I thought, very well to make sure that this wasn't just going to be a bonfire of lighting all through the night with everything turned down 100%. If you don't need it and it's not necessary for safety or security, it should be turned off between 10 at night and 5:30 in the morning.
Others have thoughts, comments?
Might be worth keeping for the second and third sentences. The first, I personally haven't seen be a big issue on planning board, but I think it's valuable to have the second and third sentences there.
I don't have any issue with it, any of it.
And I think for like for parking on the ZBA, we usually have like motion sensors for this after hours, I imagine. I
Yeah,
think we usually
there is a
we have that somewhere.
motion. Yeah, there's a motion.
we usually ask them to have all their parking. I mean, not if it's outdoors and from a pole, that's usually not motion when it's,
Yeah,
pole lighting, but if it's underground or, under the building lighting, that's usually on motion.
yeah. Number 10 has it in connection with hours of operation.
So another question on number 7, outdoor signs. Is this duplicative of the sign bylaws? Or does it create any sort of conflict with it? And
That's a good
we,
question.
and I know that the sign bylaws here are a bit over the top, and we will likely want to revisit that. The board that had created the secondary district is now defunct, and there's been a changeover in approach. It may be worthwhile seeing if we can collapse some of that information down. But this one looked like it seemed duplicative of some of the information in the signage bylaw, and perhaps it should be here because it is lighting related, and just reference the sign bylaw.
I'll make a run through the sign bylaw and make sure that it doesn't conflict. Thank you.
And similarly with flickering and flashing lights, because that's also in the sign bylaw as well.
Okay. Do you have a bylaw? I don't recall if there was anything in there for electronic messaging boards.
They're they don't allow for moving signs.
Yeah, do you want to change that? It used to be exactly what you said. It was very difficult to find a bylaw that allowed a moving an electronic message board to change. And now, they're so common.
Change. I would not advocate us making much change to the sign bylaw in that way, because of the ways that moving signs are being used. There are 2 use cases that are very current that are of particular interest. So there's one that exists at least in a dozen places in town, and that's at every lottery outlet. All of the lottery outlets have been receiving new signs, and those are actually message boards. So at the bottom of it, it'll say in a number for the Mega Millions and the Powerball, and at the bottom it'll say either million or billion, and that is technically a message board, even though it doesn't change very often. It doesn't flash or anything. The second is that we have a fairly new installation at one of the churches where they have an outdoor large message board. And whether that's a good or not good thing, I'm not going to opine on, but that is also a use that is existing, and I don't think we would really want to venture into that politically. I think that that's one of those landmines locally that would, if we were to change the text of that in a substantive way, we would run into a lot of side effects. That's just my 2 cents on it.
Okay, no problem.
Others, again, welcome to contrarian opinions.
I agree, Dan. I wouldn't touch substantively any sign issues for us.
So
Okay.
Mark, you can take that as a sign of the times.
All right, nice pun. I'll move on to noise. So this, I just finished a 4-day trial with an acoustical engineer or two. And, this is, especially in larger developments, there's a state regulation, it's cited in number 1, under noise. And it's 310 CMR 7.10, which is administered by the Air Quality Division of DEP. And the standard is that a stationary source cannot generate a sound level of more than 10 dBA above ambient. So the way it works is you take a read on the slow scale for the ambient when the noise is not occurring. And then you take a read of the noise once it occurs. I think it's on the middle scale. And you then assess whether or not it's 10 dBA or more above ambient. 10 dBA above ambient is generally considered to be a doubling of the sound, which most people find annoying. If it's somewhere between 3 and 5 or 4, it's barely perceptible. And in the middle between 6 and 9, you're climbing the ladder a little bit. The land court has been all over the place on this in terms of whether the noise is bad enough that somebody has enough injury to claim standing. I lost a case at a warehouse. It was a proposed demolition of Lakeville State Hospital and the construction of a 400,000 square foot warehouse. The nighttime reading at the quietest time in the worst location was 6 dBA above ambient, and Judge Spicer ruled that it would bother them and disturb their sleep, and he gave them standing on that basis. So this is important stuff, because if you don't have standing, you can't be a plaintiff. And standing doesn't begin at 10 just because the DEP standard begins at 10. It's important to see how the courts have shaped the notion of injury somewhere between 6 and 9 as well.
So for those who may not be familiar with the decibel scale, it's based on a logarithmic scale. So just a little bit of background. I'm not an audio expert, but I know more about it just because of my own hearing issues. And decibels, the BEL part actually is named after Alexander Graham Bell, and we no longer use Bell as a standard, but we use decibel, which is the way that the sound is typically measured. And so it's a logarithmic scale. So something that is 60 decibels is effectively twice as loud to the human ear as something that's 50 decibels. When things start to get very dangerous, when you get overexposure to things above around 85 decibels over time. So just so people understand what we talk when we're talking about 10 decibels, if you're going from 30 to 40, you probably wouldn't even notice it much. Most libraries and so forth are at around somewhere around 40 decibels. Most dishwashers operate between 42 and about 60 decibels. And it's a wide range because it depends on the amount of insulation. Most of the modern dishwashers, and I use that because if you're standing next to a dishwasher, you may or may not even know if it's on. If it's at 42 decibels, you may not know. If it's at 52 decibels, you probably do. That's the difference in what we're talking about. If we're going from an ambient noise of, say, 64 to, say, 74 decibels, you'll definitely notice that change outside. 64 decibels is not an uncommon type of noise of what we would experience. And if someone wants to get an idea of what this is, if you have a smartwatch, many of the smartwatches have the ability to actually do some very basic decibel measurements, such as I've got an Apple Watch, and right here with me talking, it's between 65 and about 70 decibels.
So this is a measurement that is used in two things. DEP standard is used as a permitting mechanism, because remember, this is not actually occurring sound. It's projection of the sound that will occur once the facility is up and running. So the typical things that it's being attached to would be HVAC equipment on the roof, ventilation equipment. It doesn't really apply to transient noise or ephemeral noise. And it also would apply to trucks, to the extent trucks are idling on the premises. They can make sound projections based on that too. Typically, it doesn't apply to backup beepers, at least as far as the DEP regulation is concerned. And that's one of the most bothersome noises that a larger facility produces. But they'll come down on you if you have an established operation and you exceed the standard. Years and years ago, I represented a cafe owner in Oxford, out in southern Worcester County, and he had the bright idea of setting up an outdoor cafe. And we actually had a jury trial, but the acoustical engineer testified that he did not exceed 10 dBA, but air quality made him enclose it eventually. And they did him a favor, because now he has weddings indoors 4 seasons a year, whereas before he just had Jay Giles band in the summer. So not a bad deal. These other 2 or 3 things here for hours of operation are just about using common sense. So no trash collection or handling of building materials between 6 p.m. and 8 a.m. No using tools outside, drilling demo work between 6 p.m. and 8 a.m. And construction devices, compressors, jackhammers, bulldozers, cranes between 6 p.m. Between 8 a.m. and 6 p.m. Even in the normal workday, has to behave itself more or less. And those are not anything to do with state standards. It's just, in my town right now, we're having the annual gas-fired leaf blower discussion, which they are banned. They will be banned in Concord. I believe it's in 2027. But it's so bad that people want them to be licensed until they're banned, with basically to discourage their use even before the prohibition starts.
That sounds like a lot of hot air, or at least
Yeah,
blowing air.
it is. But we're a town that there was a Warren article years ago to license cats. No, to put cats on, outdoor cats had to be on leashes. That was one of our better Warren articles. All right, so site development standards talk about.
So, sorry, Mark, Dan, can I just jump in on the noise?
Yes,
Sure.
go right ahead.
Yeah, so our current bylaw does have some rules around construction and what times it can occur. I think it's like 7 a.m. to 7 p.m.
Yeah.
So I just would want to make sure that it's consistent, especially I think part B and C relate more to construction.
And is that a general bylaw, if you know, or is?
Yeah, I think it's 154-6.
That's a general bylaw. I was also wondering, the way that this was currently worded, was it the Board of Health administers the noise provision as opposed to the inspectional services? Do we need to specify who is the enforcement agent for it, or can it be anyone who can do that measurement? Because there are now a lot easier ways to do the measurement itself. It used to be very hard to do measurements of sound. Now the devices tend to be more readily available. And I just concerned about trying to get the Board of Health to buy into something along these lines. They may be okay with it, but that's not something that I've heard them want to get into this particular area.
Well, if we're talking about the hours of operation clause here, it doesn't necessarily need a measurement.
It's more of a number one.
Right. Number one is a permitting provision, and the only person really who can make that measurement or that projection would be an acoustical engineer, because they're not just throwing their finger up in the air. They're for HVAC equipment, for example, they need to know the brand, the make, and they can use that information to make a very accurate projection of the sound that will actually occur.
It's the last sentence of number one there, the limitation, that's
Yeah.
referencing the Board of Health. That's where I'm just looking and saying, I'm just not sure that if that sentence is needed in Wakefield.
Okay. I think
Others' thoughts on that?
I think the Board of Health did take care of these issues. In the past, I was on it, way back when, but now realistically, it would be a combination of the Board of Health and I'm thinking the DPW. So we may not need that. It would just be someone in the town that could do it. And Tim, I'm so glad you brought that up, because in my mind, I was almost sure it was 7 a.m. So that's good to make sure we're consistent.
Yeah, I'll look up I wrote down the number of the general bylaw provision, so I'll take a look at that, 154-6. So the next section is site development standards, and it's just really an attempt to tell people, don't cut everything down in the first 15 minutes, because that is going to create a mess. And when you do go to design what happens on the site, then take care to avoid impacts to rare and endangered species, away from the crest of hills, don't detract from scenic qualities, blend with the natural landscape. So these things, again, are pretty much oriented towards common sense. Just give you the full flavor here.
So Mark, I don't think that these are necessarily negative. I'm wondering about the viability of putting that in at this time, even next year, because of a certain vocational school that is not consistent with that site design. It would not be consistent with that site design standard. And now it would certainly have the ability to be waived if the ZBA had to even hear it. It's more a matter of the opposition to it is quite vocal. And so I'm just wondering if that's something that we even want to list locally. So this would be site design for A and B.
Just out of curiosity, is it Dover protected?
No, it's currently actually in court as well. They took virgin forest and cleared it to move the vocational school for reconstruction.
Okay. And is the vocational school a nonprofit?
It's a state vocational school.
Yeah, okay.
Yeah, if I may, Mr. Chair, just for Mark's.
Yeah.
Sure.
It is through the Dover, it is Dover protected, Mark,
Okay, yeah,
if that helps you.
yeah. Okay, so I've scratched 4A. Anything else jump out here? Let me just walk through the rest of it so you see the full array. If the building has historical, it just needs to be referred over to Historical Commission. Don't just clear cut. If you have a need to cut, then revegetation shall occur under the standards limited or stated there. Limit of clearing, again, these are pretty much the same
Is
idea.
7 days sufficient for revegetation? I was wondering if that should be, say, 30 or 45 days. Just I just looked at it from the time that it's cleared from final grading. Because the final grading may be done before the construction is effectively finished. So that's where I'm just, and obviously the standard could be waived. I'm just looking at 7 days in anything, anything is a standard by construction standards yields a lot of variability, especially in New England with our weather. And I get the, during the planting season, I'm just wondering if 7 days is sufficient for someone in that industry, or if that standard should have a more, slightly longer expectation.
All right, I bumped it to 30. We'll put that in the next draft and see if it sticks.
And if others have thoughts, please by all means chime in.
So here are the last ones. Topsoil irrigation. I would assume that you're like most towns, not allowing irrigation to take place out of the public water supply.
I was wondering about that one because that in Wakefield, they may actually prefer it to come out of the water supply just from a cost perspective, especially for commercial that would distribute the costs of the water infrastructure more to the commercial side than the residential side. Because this becomes a real question. I don't have a problem with it allowing a well if it exists, but where there have been enough issues with various groundwater sources and so forth, I was wondering if I'm not sure that that standard should really apply overall and try to push the usage of water away from the MWRA water supply, where again it's a shared resource for that infrastructure. That was just my 2 cents on it, where I looked at it from a homeowner's perspective and a residential perspective, that if there's commercial use of water, it distributes the fixed cost, which is the dominant cost of it, to those entities. Others' opinions and thoughts on that?
Well, Mr. Chair, we, on most of the projects we approve, we want irrigation. It's not even a question.
You what? I didn't hear you, Joe.
So we ask for irrigation.
But the
We don't-
question
it's
is,
not like-
should it be well water or not? This is because this one doesn't talk about whether there should be irrigation, it's that it should be well water as opposed to.
Well, it says
as
may
opposed to-
require. It does say may require, so we require it. It's not there is no may about it.
But do
I
you
was just
require,
confident-
do you require it to be come from a well water?
we
Requiring the
never-
requiring the irrigation is different. It's more a matter of where the water source is. That's what I'm taking an issue with.
Joe, do you
No, we've
require it
never-
to, you require it to be private or MWRA?
We don't, well, we've never mentioned well water from the time I've been on it. But no, it's
So-
usually MWRA, Wakefield
I get
water.
it. I get it. Thank you.
Yeah.
Others' thoughts on this?
And Dan, the way I read it, I don't think it would be problematic because it's only a well water after consultation with the water department. So I would think that they would have input whether or not the irrigation should come from an on-site well.
I looked at that and I'm trying not to put in something that doesn't seem relevant at this point with the approach that the town has been taking. That's just where I look at, and knowing that there's been a lot of discussion about both the costs and the sources of water and what's happening with the water table. Do we want to encourage well water use? Do we not? Do we even want to give an opinion on it? Again, I have no issue with encouraging irrigation. I think that's fine. It's just a matter of, do we even want to mention the source, where, as Joe said, it's not been an issue. I'm not sure that we necessarily want to introduce that as a standard. That's just my 2 cents on it. Attorney McGrail, since you have represented quite a few commercial developments, if you've got any thoughts here, certainly welcome your input as well.
Yeah, in 35 years, well, almost 35 years of practice, I've never seen in Wakefield, it's all, as you said, it's MWRA, so it's never an issue. It's certainly not a concern. It hasn't been a concern, I should say, that the board will require well water. They never have.
Okay. Should we just take this out?
That would be my recommendation.
Done.
Sorry,
Alright.
which part are you taking out? The whole section or
Num-
just like that after
No, the whole, number 11,
provided?
all of 11.
Okay,
I'm not making the changes on the share screen because I've got a hard copy in front of me, just so you know, I'm taking notes. All right, I'm going on to traffic, 6.3.7. This is a very
sorry,
comprehensive.
before we move on, can we go back up to the 4A? I wanted to see what that was. We were saying, it sounded like the recommendation was to remove it.
Yeah.
Can you just
Exa-
scroll back
ex-
up to what it was?
Oh, I'm sorry. Yeah. Will do.
Thank you. And Dan, were you saying A and B?
I was saying A and B, we may want to just figure out, do we want those standards to be in here for site design, or do we really want it as standards, or do we want that to be something that, to what Joe was saying, it's really more discretionary, and if there's a change, it would allow, it doesn't discourage change just for the sake of having what's currently there, because I don't see the placement as being something that would actually be relevant to, a scenic quality, so to speak. If there's going to be a development, I see this being waived in pretty much every project. These both A and B actually being waived in pretty much every project that comes before the ZBA in practice.
It's kind of weird to just leave C. Should we take C out?
C, I would actually recommend that, because we do actually have forest, I would recommend that we leave C in. We could potentially leave B in and just know that it could be waived. I just don't see the need to blend as a standard. I think that's something that, if there's going to be something that needs special permit, the design is something that is going to be debated heavily anyways. That's just my 2 cents on it. I'm fine with leaving them in, if the committee so chooses. I just don't see these being followed, and I'm trying to avoid there being too much debate over, okay, so what would happen? Would this project then get thwarted? Would that project get thwarted? So I'm just trying to think of the optics of approval in certain areas that I could see getting us into political discourse if it's not going to actually be followed.
Okay.
That's just my 2 cents. But if others have other opinions, I could certainly be swayed.
I mean, it's very subjective. So I hear what you're saying. I did just have one other question. You mentioned the application of this, or like this being potentially used in discussions around opposition to the new school. If this were to be passed and we included it, would that retroactively apply to that project?
No, that project, the short version is that project has nothing to do with any of these standards. That project's already, it's exempted through other purposes. If I can try to summarize where I think Attorney Bobrowski is going to go. Did I summarize that in a reasonable way?
Yeah, how far is it along in the permitting process? Does it have a building permit yet?
I don't know the answer of that. Attorney McGrail, do you know? If
I'm not involved in that project, so I don't know where it stands.
Yeah, so the law says that a project is subject to a zoning bylaw if it does not have in hand at the time the first ad of the planning board public hearing appears in the newspaper, a building permit or a special permit. You know, I don't think that kind of school, which is a state school, would need a special permit because the supremacy clause takes away that requirement. It probably obviously needs a building permit, but when I put it that way, it's a supremacy clause issue. None of this is going to apply to it, period. That's the answer.
Mark, aren't these only standards for special permit and site plan approval anyways? I mean, they're not
Yes,
like requirements
for
of the bylaw.
non-residential projects and
Yeah.
larger multifamily projects.
But that's
Not-
only
not-
if they're going for a special permit or a site plan approval.
Right, exactly.
Yeah, so I don't,
I took out
it's
the
not like it would be a
procedural.
general provision of a requirement of the bylaw that would grab onto something like that. I think it's
No,
gonna-
it has nothing to do with your house.
Yeah. But even if a project is approved, like if a project is approved, or if a project is not required to go through a special permit or site plan approval project, like Dover exempt, this doesn't grab onto it anyways.
Exactly.
Yeah.
Okay, so now we get into the cars.
Thank you. Appreciate it.
No problem. So this is just, again, some common sense. Access has a sort of hierarchical approach here. Common
Mark, I'm sorry,
drive.
Can I just interrupt for 1 second? I apologize, but did we skip number 12, phasing of development?
I thought there were no comments on it, but you can correct me.
I just didn't, what does that mean? I'm just confused by it. After, may
I
limit the
think-
extent of a site exposed. What's it? I'm just.
Cut to the ground. In other words, phase the clearing of land.
Okay. Okay, thank you.
Yep. So the first one, access, just lists the acceptable kinds of access to a major site. Access via roadways abutting residential districts shall be avoided where possible. Access to a site with frontage on more than one street. You pick the street that has least impact on surrounding neighborhoods. Driveway adequacy. Pretty much the same thing. One is getting to the site, the other one's getting into the site. All driveways designed to afford adequate site distance for everybody that's going to use it. There's some standards for curb cuts. Exceed 20 feet for residential, that would be a multifamily, or 30 feet for a commercial property. And the locations will be picked for convenience and safety. You should have as few curb cuts as possible. Safe interior circulation for everybody on the site. Transportation plan approval is generally a way to encourage people not to bring their cars to the office. Well, no, that's
more of D, I think.
yeah, that's TMC, transportation management component, as part of the transportation plan approval. So this is coin of the realm is a Massachusetts TIAS, which has very specific standards established by the Commonwealth. It's also regulated to some extent by the Institute of Traffic Transportation Engineers, which also has its standards for TIAS. But A TIS is a standardized document. We all know enough about them at this point. If we've been sitting on boards, it's got total trip generation. It's got trip distribution. It has crash data. It has site distance. It has level of service analysis at both signalized and unsignalized intersections. This basically says that if you're going to establish something with 25,000 gross square feet, you're gonna put a TIS together, and the TIS will have a TDM, a traffic demand management plan. That's the one that is detailed here. That encourages people to do something other than drive their car to work. So shuttle services, employee carpools, rail passes, monetary incentives, on-site shower facilities so that people who bike to work can clean up once they get there.
So for section D, one of the questions, I looked at that and I looked at the various developments in town that I know have tried, some of which have tried this. Does this actually work in practice in a suburban setting?
Absolutely.
And I ask that because the developments that I know of where this was a part of the actual plan, the rate of usage of carpools and other things don't actually work in a suburban plan, on the 128 belt. And you get inside of 128 belt, and you get where it's more urbanized. I see more of this, but as soon as we start to get outside, I'm not seeing I'm just trying to wonder about the efficacy. I'm not saying we should take it out. I'm just trying to figure out, does this actually make a difference in the amount of traffic in practice?
It might make a smaller difference out in Wakefield than it would in Somerville, but it still makes a difference. And I work a lot on the 128 corridor, and I do it with I do it with the people that I consider to be the finest transportation engineers in the Commonwealth. Jeff Dirk from VAI, Bob Michaud from MDM, Ken Cram from Bayside, and they routinely put this in even further out. So if it's a large project on the next beltway out, 495, you'll see this pretty standard in the TIAS.
Okay, again, I don't have a problem with it as a standard and an expectation. I'm just trying, I can see there being some skepticism, and one of the developments that comes to mind is Edgewater Office Park, which you may be familiar with on the Wakefield-Linfield line. It was developed, and I believe it has a traffic management component as a part of its plan. Every building has public showers and things along those lines, and they almost never get used in reality. I used to have offices in several of those buildings, and it was there. It would have an area of a bike rack. It was done. Even when I talked to one of the building managers, they're like, "Yep, that was done for show so that we could actually get things built the way that we wanted." So that's
Yeah.
just where I look at is, as opposed to a building that's on a commuter rail or on public transportation where people can use multimodal transportation.
Well, it's even a better question, Dan, in the post-COVID era. I don't know about anybody on this Zoom session, but I pretty much have decided to work out of the kitchen at this point. I have an office, it's a mile and a quarter away, but I'm just more comfortable working at home.
Perhaps that should be something that actually gets added in here, is to encourage telework.
Okay, that's a good idea.
Does it as a way to manage traffic?
Yeah. All right, so the level of service stuff starts, it gets a little bit. You have to be site specific. So I was just reading Norton's.
Mark, can you scroll up to the last part
sure.
of the parking again?
Yeah.
All right, did you take out, I think I have a prior version where there was like a reduction in parking section. Is that in here somewhere, or did you take that out?
It might be in parking. Let me, hang
The
on.
number 9 talks
Yeah,
about
no,
parking.
down, right.
Okay, that's fine.
Okay.
Never mind.
So level of service is a measurement of delay. It has both a signalized intersection approach and an unsignalized intersection. I mean, obviously at an unsignalized intersection, the toughest maneuver is probably the left-hand turn. And so there's different reads for the left-hand turn and for the right-hand turn. If it's a signalized intersection, it's better regulated. A D is not a bad score. It sounds bad, but it's not. And it's like it's like your report card. F is awful, but we live in Eastern Massachusetts, so we're all used to Fs. We drive through them every day. You'd be surprised at people who live 45 miles from town and what they think is bad traffic. Here, we'd be delighted, but it's just a function of what you're used to. So if you're going to result in a measurement below a rating of D, you got to basically come up with a cost estimate to try to improve the intersection. And if you're going to result in a reduction of a letter grade or an increase of 10 seconds of delay, you may be required to provide plans with a cost estimate that would restore the situation to the current to the current level.
What are traffic circles considered?
Traffic circle in avoidance of a stop sign.
Correct. We have a couple of rotaries, traffic circles, and they're very complicated. There's one at Route 129, and it's a double lane and very complicated marking type of intersection. It's relatively efficient for the way that it's marked. It's just a matter of I'm trying to figure out, would that be considered signalized or unsignalized? Because while there's no lighted signals, there's lots of signage.
I wouldn't be considered signalized unless it had a signal. It would probably be
lighted signal.
Yeah, I mean, it might be, some people might categorize it as a traffic calming device, but I mean, I live near the Concord Rotary and we're world famous, so.
Yeah, there's nothing about the Concord Rotary nor the Route 129 Rotary that it makes people calm.
Well, they'll get calmer at the Concord Rotary because the prison is shutting. The state has decided to close it, and this summer, the last prisoners will leave, and that 50 acres will be available for something. Nobody knows what yet, but it may be that they decide to fix the damn Rotary. So we'll find out. Which brings us to dangerous intersections. So there's a dangerous intersection would be something that has an accident history. Every intersection you can get crash data for the intersection, and then a traffic engineer will be able to tell you whether or not it merits special attention because of the crash data. Sight distance is the distance. That's not the right way to spell it. Is the distance that you can see up or down the road from the height of your head in the car. And it's also a measurement of what a person on the road can see at the intersection when they're approaching it in terms of safe stopping distance. And these are very standardized measurements that are set forth in AASHTO, which is the abbreviation for the association there. I love traffic engineering. If I come back, I'm coming back as a traffic engineer. I'm not such a fan of this maximum parking. I don't want to encourage this anymore. That's a lot of parking. So if you're required to have 50 spaces, you can have 100? I don't like that anymore.
I tend to agree. I think that anything, especially in Wakefield, if we can avoid discussions of parking, the more we can avoid it, the better. Because this is something that politically I see getting misconstrued. And if there's a site plan approval where there will be parking expectations from zoning, anything that is going to have a discussion realistically because of the price of land will be a discussion with the actual special permit granting authority. I wouldn't want
Yeah.
to designate the minimum. I wouldn't want to designate a maximum standard because it just, I think it defines things in a negative way. That's just my 2 cents on it.
Yeah, I agree. And I've tried to build into the parking a provision that says exactly pretty much the opposite. So just scrolling over to the bylaw, first draft, this is what it says under parking. And I've been using this successfully for 20 years now. But I want where you don't need all of the parking that's being proposed. And you can get a traffic engineer to say that. It probably says it somewhere else in the section. But what I've said pretty typically is that if you don't think you need all the parking, then ask for a special permit and reduce the parking. And if the board is convinced that that you're not going to hurt anybody as a result, they can grant you the special permit and you can cut back on the amount of parking. And I think that's in this section here with a lot of yellow in it. May reduce the requirements by issuance of a special permit. Evidence of infeasibility due to lack of suitable land, not adversely affect health, safety, convenience. I think that I would, this is what you had already. So I didn't change much of it, but I get more aggressive than that. And just normally what I put is anybody can ask for a waiver of any provision of the parking section by special permit from the special permit granting authority, as long as it's not going to result in public detriment of some sort. All right, back to the other document. So I'm gonna just take number 9 out, if that's okay with everybody.
Any objections to removing 9?
No, I mean, normally they're asking for less parking. Never do I hear they're asking for more parking.
Yeah, I agree. These days, you're absolutely right. So mitigation is something obviously that you can only do on a town road. You have no power over a state numbered highway under the jurisdiction of the DOT. Just want to make that clear. It's unlikely you'd be putting signals on a town road. And even if you were, you'd probably need to consult with DOT as to how it would affect nearby state highways, but that's a word on that. Bicycle and pedestrian safety, all pretty straightforward.
So one thing that struck me on the pedestrian bicycle safety is that it talks a little bit about traffic signals modification in number 11C.
Yeah.
What might be helpful here is just a statement that additional pedestrian and or bicycle signals may be needed, just to set the expectation, as we are in the process of adding more bicycle friendly components to the town, whether people like it or not, it's in the process of occurring. And so I'm just looking at this saying that would be consistent with with the current processes. And again, as it just becomes a standard that if it's appropriate, there's additional signals, and they may be specific to pedestrians and or bicycles, which can be different than the rest of the roadway and traffic.
Okay,
Others thoughts on that? And Lucy, if you can record that Anne had to depart at 8:36.
Yep.
hang in there, we're only 2 pages away.
We are near the end of this.
Wait, who?
Anne,
Yeah,
I'm
oh,
here.
you're there.
Alright.
Okay, you just jumped on my screen. Sorry.
I was wondering if there was another Ann. A little slow on the take there.
all right, so parking areas, favored locations would be side or behind. Generally, this also is accompanied by number 13, which says you can prohibit parking within the required front setback in appropriate circumstances. So that's the location preferences here. And then under traffic calming features, crosswalks, bike lanes, rumble strip, landscaped islands may be required. I remember when we did Legacy Place in Dedham, I sat with the planning board as their lawyer. We were worried that the traffic estimates were going to be wrong with regard to cut through in the nearby neighborhoods. So we actually said that it had to be monitored, and if it got too bad, the following calming measures were going to be installed in phase 2. This was after the permit was issued. I think it was 6 months or a year, but it was all laid out what would happen.
Could I make a suggestion that we replace rumble strips, which tend to be very noisy for neighbors, with speed tables?
Yep.
We're not allowed to have speed bumps. Those are deemed unsafe, but speed tables are the raised tables that you'll see, especially near intersections,
Yep.
and they tend to be very effective.
All right, these last 3 sets of standards begin with aesthetics, utilities, and the last one is fiscal assessment. I once had the enormous chore of reviewing Newburyport's architectural standards, and I've never seen the words Greek revival occur more often. I try to just keep this simple and straightforward. It could be a lot stronger, but you'd need an architect to come up with something that's viable here. So I'm just trying to keep this at a very superficial level. If the building obviously speaks for itself and it's out of scale, bulk massing and density with nearby buildings in the area, whatever. Bring them back to size. And I can't recall it. Do you have a design review committee?
I'm not aware of an independent one at the moment. That function, I believe, is absorbed by both the planning board and the ZBA as appropriate.
Okay. So this section on utilities, again, pretty straightforward. The wastewater treatment and disposal is consistent with local regulations on the Commonwealth. Sufficient water capabilities to meet, I don't know what that.
It looked like there was a search and replace
Yes, there was a search and
of city for town. So
Yeah.
we went from capacity to Kappa City to Kappa Town.
Okay, I get it. Right. Well, this was probably last used in Medford, I want to say.
So if
Sufficient
anyone else was
water.
was reading this, I figured out what was going on here. It was quite funny. So the word capacity is now capital.
I'll go back and fix that. Site security, the fire chief is gonna sign off as well as the police chief, especially on the fire alarm system.
Is it is this standard that it's now requiring something by the police chief? The fire seems pretty consistent, but I'm wondering about site security, and I'm asking this for two reasons. One is this seems like it's creating a potential new burden on the police chief for site plan review as opposed to a mandatory type of review as opposed to something that could be required or asked by the special permit granting authority.
Dan, I think it's mandatory. I think they have someone dedicated at the police department that does the fire alarm systems for all.
Fire alarm, yes, it's more
development.
that which that's different because just in terms of the state mandates and the way that fire systems are managed. Police is a little bit different because it tends to be much more subjective.
So I had a situation in Southborough where a gentleman was permitting a very long building. I think it was going to have 20 bays, or maybe it was 40. I can't remember. And in each one, he was going to have a different tenant. And the question was, what happens when the building, catches on fire or something? You don't want the first responders not knowing what's there, because obviously they're going to be jeopardizing their own health and safety and the public health and safety. So, and I think that kind of speaks to issues here that the police chief and or the building commissioner have to be involved in.
Mark, do
But
we need this in here since this is a code issue? It's under permit. I mean, it would fall under the permitting process, right? It's not up to it's not up to the ZBA to make sure they have the fire under control, like the fire alarm system up to date. I mean, they find that out when they go to permitting
Well, that's definitely a
in
code
code review,
Yeah.
also.
That's definitely an issue. That's a code issue. But the use of the premises, behind a locked garage door raised a lot of questions in Southborough, and I thought they were appropriate. And I was representing the applicant.
So what I'm thinking here, and sorry for interrupting, is that may resolve this is if we just put the police chief or fire chief or their designee, because they may want to delegate that authority in certain cases to the building inspector or someone else, depending upon the situation. Because I'm trying to protect the time of the police chief and fire chief personally while still getting the concepts in.
Yeah.
And this allows them to explicitly do designations, because yes, we do have a signal and a signal inspector for fire alarm systems and things along those lines. And for site security to then have the standard there so that at least the police department is aware of a new development, that I don't think is a bad idea. I think we're seeing that with one of the bylaws and the marijuana bylaw specifically, that has already come up as to, okay, what type of issues are there? So I'm not opposed to it. I just think we want to allow them to have the ability to designate who they want there. That way it doesn't require their personal sign off.
Okay, I get it. And then the last one is fiscal analysis. I would not make a decision. I see another Capitown there. I would not make a decision based on this information, but it sure as heck is interesting to know. I recall the time I worked with Judy Barrett in one of the towns west of Worcester, Leicester. Leicester zoned for big box. They wanted the tax revenue. They got a Walmart. It was site plan review only, not special permit. Judy, who is very good at assessing fiscal costs and benefits, basically took their promised tax payment of, I think it was $175,000 a year, and she contacted a nearby town that had the same size Walmart, about 200,000 square feet, and was informed that it generated 800 police calls a year. So there goes your money. And I wouldn't deny it on that basis, but I sure would want to negotiate differently with somebody who was promising me $175,000 in gross tax revenue, because the net in that situation was under 100,000, according to Judy.
Thoughts on this? I thought it was an interesting way to get that information. Especially for new developments, to have that fiscal analysis, I think would be very useful for the townspeople to know, to then be able to have a more informed decision and recommendation going into what they're recommending to the representatives who are making the final decisions. So I'm thinking if people can see this information, I think it also will help with the veracity and the integrity of the applicants when that information can be looked at by the respective zoning authorities. So I actually really appreciated having that. I think that's a new area for the town. I think that would be very helpful. That's my 2 cents on it.
Yeah, there are people who do this for a living. And, if you're interested, I can give your board's names of people that are quite good at it.
Others' thoughts on any of this?
It is interesting as well to me, because these are questions we all ask when a project is put before us. I'm just thinking, when I was on the Board of Selectmen, you would ask what the additional costs were. So if they came in with an analysis, I think that's interesting.
And to be able
Yeah,
to question the analysis. And I think that becomes just as valid.
Yeah, it's fascinating because it's all good news as far as the applicants are generally concerned. We're going to pay X in taxes and you're going to be real happy. Well, if they're not telling you what they're going to require in costs in order to make this town infrastructure work for them, you're only getting half the story. For example, in Leicester, when we presented that information to them, they increased their offer of mitigation. I think we got at the last minute, we got some sort of a hazmat trailer that, the first responders could use in going to sites. It was something to the tune of another 50,000 in mitigation. And like I said, it was as of right. It was site plan approval. They didn't need to do that. So.
Okay. Any comments on anything in the sushi menu? Otherwise, has
Mark,
everyone had their fair share of sushi? Joe?
Yeah, real quick, Mark, my first concern, have you ever had towns, like I said, concerned about this on projects where they meet all these criterias on a project where they may not like the actual project? Like, you know what I'm saying? So
No,
if an applicant comes with a project that doesn't fit the town's nature, but they say, hey, I followed all your standards here. it should be a shoo-in. I should be able to get approved. You have,
Well, I
have
had
that
that
situation.
case, Joe. No, that's not the way, you are probably going to hear that from the applicant, but that doesn't make it true. So just as an example, many years ago, I had clients in Andover. And they were smart enough to look at a train station condo project. The town rezoned about 10 acres of land for a condo project because they didn't want it to be called spot zoning. They put another piece of property into the district just to say it was, a bunch of properties. It sat there vacant until my client realized he was owned multifamily. If he bought the property instead of a single family home, he could put up 8 apartments. And it's Andover, so they're a smart town. They met every criterion for approval: A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, to the letter. We went to the ZBA and they said, that's the finest presentation we've ever heard. I had John Mullen, the chairman of the regional planning department at UMass Amherst. I had Bob Vanass, who's from Andover when he was just Bob Vanass. And I had a local engineer who was wired. They took a site visit. They came back at the next meeting and they denied the project. And the reason they denied it was because even though we met every criterion, the train station nature of the neighborhood had persuaded a couple of the board members, at least, that when people came home for lunch, they weren't going to park in their parking spot on the property. They were going to park on the street and increase the congestion around the train station. And that stood up in court, land court. So it's just because you meet all the criteria doesn't mean that the board's discretion goes away. They still have discretion. And they only need one good reason to deny it. They
All
don't.
right, thanks. I mean, yeah, because that was a couple of the members on the board, that was their concern.
A
some of
special
these
permit
projects.
a special permit is a jump ball. There's no entitlement to it. I think a lot of board members, they probably know that, but they don't realize how powerful that tool is in terms of saying no.
Thank you.
Anyone else? Thank you, Joe. Hopefully that will give you some good feedback that you can share with your colleagues on ZBA as well. It sounds like probably help allay some of their concerns.
Yes.
So I see you have another meetings. You've got town meeting coming up, and then you've got another meeting set up for May.
So that does bring us, we for our upcoming dates, we've got 2 dates that I put on the agenda as possible dates. May 6th, there's I'd like to hold that date if possible. It may not be feasible if town meeting actually extends to that, because that would be the 3rd session of town meeting. Again, at this point, I don't think, based on my history of attending town meetings here for about 25 years, I don't think we will go to a 3rd session. I think it'll be done after 2 sessions. I think the town meeting members will just not have the desire to come back for a 3rd session. So that's why I think 2nd session may be long, but I think it will end there. But if there is a 3rd session, it's most likely going to be Monday, May 6th. So that's the first Monday in May, and then the natural 3rd Monday in May would be May 20th.
I've got something on my calendar for the 6th in Grafton. A 40R that was voted back in the fall is now coming around for its first session of plan approval at the planning board. So I'm gonna bag off that night, but put the 20th in my book, Mr. Chairman.
Okay. So with that,
I would suggest that if you wanted to make productive use of the time without me, that you go through the new definitions, which I can isolate in a separate file and send to you. And everything that is new will be colored yellow, so I can make your job easier.
If you can do that, that would be helpful.
That'd be great.
So thoughts from members? Should we plan for Monday, May 6th, or should we defer just till Monday, May 20th?
Mark, Dan, I'd probably personally say we defer to the 20th, just knowing that town meeting is the week before. We may be a
Yeah.
little burned out, to be
Yeah.
honest, but I'm open if other people want to meet.
I'm fine either way. So I just want to put it where we have the election in 2 weeks, then we have town meeting the week after that. I have no problems saying, okay, let's take a little bit of a breather, and then that would be Monday, May 20th.
Sounds good.
Okay with that.
Okay, so Monday, May 20th, it is, that'll be the next meeting.
Why
On
don't we plan on doing the definitions that night? And again, I'll circulate through the chair just that section, so you're not. And I'll make sure it's color coded yellow with the new definitions.
Excellent, thank you. And I will post that to the actual bylaw review page for anyone who wants to see that, because that'll be a significant entry. Even though the definitions and so forth are already posted, I'll post that just to highlight what is new and different. So upcoming holidays and observances, we've got Passover that starts next Monday evening. It lasts for 7 or 8 days and 7 or 8 nights. It depends upon a person's and their family's approach as to how many days it is. It's not actually all that consistent within the Jewish religion. So, and part of the reason I mentioned that, the very first night of town meeting is the 8th night of Passover. So there are some people who are being negatively affected by that. You may hear a little bit about it in the community, and it's something that has been acknowledged. Orthodox Good Friday is Friday, May 3rd. Holy Saturday, May 4th. Star Wars Day, very important for my family, is also on May 4th. May the 4th be with you. Orthodox Easter is May 5th. Cinco de Mayo is also May 5th. Cinco de Mayo is largely an American holiday. While there is a Mexican connection to it, it's largely celebrated in the U.S. Orthodox Easter Monday is May 6th. So again, mentioning that, and Yom HaShoah, which is the remembrance for the Holocaust, is also on May 6th. So a lot of things that are happening over the next 2 weeks. I only put the holidays up to the first of the next meetings. That's where these come from. If you're ever wondering where the list comes from, when does it end, that's what I'm using as the determination, partially just to raise awareness that there's a lot of different holidays, celebrations, and other things that are occurring in the community as well. But please don't forget Star Wars Day. It's a good opportunity to get our lightsaber and other things. At the next meeting, according to our bylaws, just so everyone's aware of, there will be an item on the agenda per the bylaws themselves, where we will again have a election of chair and vice chair, just because it'll be the first meeting after the town election, and that's something that we're required to do by the bylaws, just so that we can specify it on an annualized basis. So that's something that you'll see on the agenda, and we will handle that. It will probably be a very quick item, but it's something that will be there. And then we will focus on the definitions. So Monday, May 20th, roughly it'll be 5 weeks from now. And please make sure that you vote. Please make sure that you attend town meeting. There'll be a lot of discussion between now and then take a look at definitions once we get those back from Attorney Bobrowski.
With that, I'm gonna let you go, and everybody be safe. I'll see you in 5 weeks. Thank you.
Thank you very much. And with that, we have one final vote to take, and that's a vote to adjourn. Do we have a motion to adjourn for the evening?
So moved.
And is moved. Do we have a second?
Second,
Seconded by Kevin. So motion's made and seconded. Any discussion? Otherwise, with that, we will take the roll call vote in the order in which you presently appear on my screen, and you still appear first.
Aye.
Tim,
Yes.
Joe,
Yes.
Kevin,
yes.
Lucy,
Yes.
and I vote yes. So with that, meeting is adjourned at 9:02. Thank you, everyone, for your time. We actually, I think, made a lot of good headway this evening, got through a lot of really dense material. So much appreciation. Thank you much. Have a